Good morning. My name is Michael Fix, and I am the president of the Migration Policy Institute. I want to welcome everybody to the call, digging deeper into executive action, a further examination of the impacts. I just want to start by noting that while there's been a lot of attention to some of President Obama's executive actions, particularly the relief from deportation or deferred action, there's been less focus on other really major aspects of his announcement. In the next hour, my MPI colleagues are going to review some of the important, if somewhat overlooked changes, cross-agency changes that range from altered enforcement priorities to policies that promote immigrant integration. They'll also be discussing some of the issues and challenges of implementing these changes. First, if you would, a housekeeping note, MPI's Deferred Action Estimates and our data tool on Unauthorized Immigrants, both of which provide both national and state-level data, are available at migrationpolicy.org. I want to remind everyone that the audio and PowerPoint from this webinar will be on our website later today. If you have any technical problems, please email events@migrationpolicy.org or call 202-266-1929. The best browsers to access the webinar are Google Chrome or Firefox. If you have any problems hearing via the web, please dial in using the call information sent to you via email. We're going to have a question and answer at the end of the call, so feel free to type any questions into the chat box on the left side of your screen or email them to events@migrationpolicy.org. And I want to apologize at the front of this webinar. If you hear a faint hum in the background, it's because they're doing unwanted construction on the basement of our building here at MPI. This is going to be a packed hour, so I'm going to proceed to introduce our presenters. First, Mark Rosenblum, Deputy Director, U.S. Immigration Policy Program here at MPI. Our second speaker will be Doris Meisner. Doris is Senior Fellow and Director of U.S. Immigration Policy Program. Our third speaker will be Muzafer Chisti. Muzafer is Director of MPI's office at NYU School of Law. And our final speaker this morning will be Margie McHugh, Director of MPI's National Center on Immigrant Integration Policy. So with that, let me turn the floor over to Mark. Mark?
Thank you. Thanks, Michael. So as Michael mentioned, attention to the President's announcement has largely focused on the new and expanded deferred action programs, but the announcement was actually quite far-reaching and touched on several different aspects of the immigration system, including important new enforcement practices, in addition to the deferred action program, other forms of relief for certain unauthorized immigrants, expansion of opportunities for high-skilled immigrants, and promotion of integration and naturalization. So we're going to say something about each of those, and I'm going to begin by talking about the new enforcement practices that were announced, and I'll say something about each of these. I'm going to just jump right into the first point, which is new department-wide enforcement and removal policy. And I think this is really one of the most important parts of the President's announcement. And what this refers to is a new memo that Secretary Johnson published in coordination with the President's announcement. And this memorandum builds on and replaces a pair of earlier guidance memos that had been published by ICE Director John Morton in 2010 and 2011. This memo rescinds those earlier memos, supersedes them, and lays out new enforcement priorities for the entire Department of Homeland Security. One reason that we believe that the memo is important is that we know that the memos that it replaces were also quite important and that they substantially shaped DHS enforcement practices under the Obama administration. Previous MPI research shows that between 2011 and 2013, so in the years after the Morton memos were published, 98% of all DHS removals were governed by those memos. They fell into the enforcement priority categories that were laid out in those earlier Morton memos. And 99% of all DHS removals in 2013 fell into the priority categories that were described by these earlier memos. So this new memo likely will similarly describe and constrain what types of enforcement practices DHS puts in place in the coming years. So the Johnson memo that was published last month updates the earlier Morton memos in 3 ways. The first thing is that, as I mentioned, it explicitly covers all DHS operational agencies and the entire scope of the immigration enforcement process. The earlier memos had been written by the Director of ICE, John Morton, and although Secretary Napolitano embraced them and described them as department-wide policy, having these new memos authored by the Secretary of the Department and explicitly directed at all of its operational agencies strengthens that sort of department-wide element of this new memo. The second thing that the new Johnson memo does is it reorganizes and redefines DHS's enforcement priorities. And it does that in very significant ways that narrow DHS's enforcement focus from what it had been. Under the Morton memos, identified 3 enforcement priorities for DHS. The first priority under the previous memos were national security threats and immigrants who had been convicted of a crime, regardless of the type of crime. The second priority was defined as recent illegal entrants, including anyone apprehended within 3 years of entry. And the third priority category included ICE fugitives and anyone who re-enters following an order of removal. Under the Johnson memo, all 3 of those priorities are redefined, as I said, in ways that narrow DHS's enforcement focus. So, and that focus it on, unauthorized immigrants who have been identified by the Obama administration as top enforcement priorities. So under the Johnson memo, the top priority is now defined as people who have been convicted of felony offenses and aggravated felonies, so the most serious types of crimes, convicted gang members, and people who are apprehended while crossing the border. So that's the top priority. And this is consistent with the Obama administration's focus on convicted criminals and border crossers, people apprehended at the border. The second priority under the new Johnson memo consists of people who have been convicted of serious misdemeanors and people who unlawfully enter the United States or re-enter the United States after January 2014. So recent entries and again, relatively serious criminals. And the third priority includes anyone who has been ordered removed since January 2014. So left out of this priority list are immigrants convicted exclusively of illegal entry, people convicted of other minor misdemeanors, including most non-DUI traffic offenses, and generally any crimes for which people are not sentenced to at least 90 days in jail. Those immigrants will no longer be viewed as enforcement priorities. Also left out are people with previous removal orders that are more than a year old. So a lot of people who were viewed as priorities for enforcement under the Morton memos are no longer defined as priorities under the Johnson memo. We haven't been able to do the math on exactly how many people are no longer viewed as a priority, but generally this will very much continue the recent trend that we've observed of the Obama administration shifting enforcement away from the interior and back to the border and focusing most of its enforcement efforts at the border rather than on immigrant communities settled within the United States. And we'll be monitoring this to see, exactly how much we see interior removals fall as a result, and looking to produce estimates of how many priority cases remain in the interior. So let me briefly talk about the other changes that were announced with respect to immigration enforcement. A second change is a new southern border enforcement strategy that focuses on 3 new interagency task forces, one to cover the entire land border and the West Coast, one to cover the Gulf of Mexico, and one to focus on investigations. And you know, these changes should be viewed in the context of the 30-year-plus effort to secure the southwest border. A lot of progress has been made at the border, and MPI research has, you know, talks about some of that progress that's been made. But DHS has been hampered to some extent by its organizational structure, which puts ICE and CBP separate operational agencies, each playing a role at the border, and even within CBP, CBP's sector-by-sector structure, limiting in some ways the agency's flexibility to surge resources and to make sure that they have their resources in the parts of the border where they're most needed. So I think this new border security strategy is designed to give the department better ability to surge resources and to make sure that across its different operational components, there's greater coordination and focus on the border and an ability to shift more resources to the border, even in the absence of additional appropriations. A third change that was announced that's also quite significant is that the Obama administration is ending the Secure Communities program and replacing it with a new program called the Priority Enforcement Program. As most of you know, Secure Communities is an information sharing program between DHS and the FBI that allows for the automatic checking of fingerprint records against DHS databases when people are booked into local jails and prisons. That automatic checking will continue under this new program, but under the new program, ICE will only seek to take custody of people who have been convicted of crimes that are identified in the Johnson enforcement priorities. So whereas Secure Communities flagged people to go into DHS custody potentially just because, you know, they were unauthorized, the new program, in its cooperation with local law enforcement, will only focus on convicted criminals. In addition, ICE will seek to be notified prior to the release of a convicted criminal, but in most circumstances, ICE will no longer place immigration detainers to request a hold beyond the end of the criminal justice sentence. So those are both quite big changes, and they also continue trends that we've already seen beginning to emerge of less reliance on detainers, less placement of detainers, and an increased focus on more serious criminals. But these changes potentially will take that quite a bit further. One of the real questions about this is how successfully ICE will be at centralizing control of this new program, and whether, you know, across different ICE jurisdictions, we'll see that focus on convicted criminals or not. One thing we don't know about this program is whether the Law Enforcement Support Center that sort of is the brains behind Secure Communities, whether it's going to be restricting information to ICE field offices and only forwarding information about convicted criminals, or whether this program is going to rely on guidance that goes to field offices to direct them to only focus on convicted criminals. And that's likely to make a difference in how the program is implemented. The last enforcement point that I want to focus on, there are several additional reforms that target immigration courts, new efforts within the Department of Labor to strengthen worksite enforcement and to protect workers' rights at the work sites, ICE personnel pay reform. The point on this slide that I want to focus on is the effort to reduce backlogs in immigration courts and questions about how successfully this whole package of enforcement reforms how successfully they will reduce backlogs in immigration courts. This has really been one of the most important challenges that the immigration enforcement system confronts, is that we've made such significant investments in frontline enforcement resources and much smaller investments in immigration courts, and as a result, we've seen backlogs and waiting times in immigration courts grow substantially over the whole last decade, including during the Obama administration. Currently, the backlog in immigration courts is about 422,000 cases, which is an all-time high, and the average wait time to come before an immigration judge or to complete, the average wait time for pending cases is now 569 days, so almost 2 years, or over 1.5 years. This has proved, as we saw with the child and family migration arrivals this summer, a huge challenge for the immigration enforcement system in general, because if the courts can't process immigration cases, then there's no way to resolve cases that may have claims to relief. And so this really hamstrings the entire system's ability to process people through the system. So what we'll be watching is what steps the courts can take to work with DHS to reduce the backlog and speed processing time while still ensuring adequate due process and fair processing, and whether by taking people out of the enforcement queue through the new enforcement priorities and through the new deferred action programs, we're able to see a reduction in the court backlogs and in these wait times. So I'm going to, I think, pass the floor to my colleague Doris.
Okay, thanks very much. All right, we now get to the set of issues that that provide relief for unauthorized immigrants, and these, of course, are the measures that have received the most attention. But even among the ones that have received the most attention, there are a couple of areas that haven't been looked at very carefully. There are 5 elements of the relief. One is the expansion of the existing DACA program. The next, of course, is the new Deferred Action Program for parents. That's the one that has been the signature piece of the announcement. But then there also are expansions of the 601 provisional waiver opportunity, a clarification of advanced parole rules, and expanding parole in place for military families. I'm going to talk a little bit about 4 of those 5, the first 4 of those 5. Okay, so the DACA program. The DACA program, of course, is one that we are already familiar with because it was announced in June of 2012. But what has been done in the presidential announcement is an expansion of the existing DACA program. The expansion comes in 2 parts. The first is to move the date of eligibility forward from 2007 to 2010, so that now people who were brought to the country prior to January 1, 2010 are eligible. And then, perhaps more significantly, the age cap of 31 years of age has been lifted. So the new DACA program no longer has an age cap of 31 years. The additional change is that DACA recipients will be eligible for a 3-year deferred action as compared to the 2-year under the earlier program, and that will include those people who have already applied for renewal. Renewal of the first 2-year DACA opportunity began last summer. We believe that about 300,000 people additionally are now eligible for DACA relief as a result of the announcement, which brings the total DACA pool to about 1.5 million annually. The most important next step, of course, is for that application period to begin. The President's announcement said 3 months from the announcement, so if we take that literally, it would mean that DACA applications would be beginning to be processed February 20th of 2015. And the issues that will be important among many will be whether the application rate that we've seen in the past persists with these changes. In the past, about a half of the people who have been eligible for DACA have indeed applied. We'll see whether that holds. And then there's, of course, the broader question of whether this expansion of DACA, along with the larger deferred action that I'll talk to in a moment, will change policies at the state level that flow from the deportation relief, things such as eligibility for driver's licenses, in-state tuition, and other benefits. Let's go then to the major program here, which is the new deferred action for parents. So what the President announced 2 weeks ago is that unauthorized immigrants who are parents of a U.S. citizen or a legal permanent resident of any age will be eligible for deferred action relief. They need to be able to show continuous presence in the United States for 5 years, i.e. since the 1st of January 2010. They also need to be physically present at the time of the announcement, which was November 20th, and when the application is submitted. They will be adjudicated on a case-by-case basis. This is not a blanket grant. It is an opportunity to apply for a case-by-case adjudication. And they, of course, also cannot be a priority for removal in the way that Mark has just explained with the new removal guidelines. But what they will receive if they are approved is protection from deportation as long as they remain law-abiding. In other words, if they receive deferred action and then commit a crime, it would not hold. But the deferred action is a protection from deportation, and it creates an eligibility for a work permit for 3 years. 3 years is the period of time that's being granted for deferred action. There will be an application fee. It's $465. There will not be waivers from the fee. And importantly, this is an opportunity to remain in the United States free from the worry of deportation, but it does not confer any kind of permanent status or eligibility for a green card or path to citizenship. Our estimates are that about 3.7 million people are potentially eligible for the Deferred Action Program. The next steps will be for ICE and CBP to start to identify people that are currently in deportation proceedings for their eligibility to apply for the program, so that immediately people would be taken from the queue in the way that Mark explained that might be ready for a hearing. And then, of course, the major effort that is underway and will need to be put into place by USCIS to handle this load of applications and what the process will be. Again, if we take literally that applications will be accepted as of 6 months of the announcement, that would mean May 20th of 2015 would be the date that people could begin to apply for deferred action. Now, there are many questions that will be important in watching this program, but among them, of course, will be the rate of application. Will this new deferred action program for parents follow what we've seen with the DACA program, which is that about half of the eligible people will apply, or might there be more or less of the eligible population who would apply? There's also, of course, the USCIS question, which has to do with handling this surge. This surge could be as many as half or more annual numbers of applications from the peak level of workload that USCIS now handles. USCIS's caseload at the present time has been about 6 million a year, with 3.7 million eligible for this new program. You can see what the orders of magnitude are. It's a major ramp up that needs to take place. And then in addition to the ramp up where process is concerned, there are the questions of the criteria and what applicants will need to show. Where that is concerned, proving continuous residence of 5 years will probably be the difficult area and the area where guidelines will be the most important for people to prepare themselves, for community intermediaries and other stakeholders to be of assistance. So the eye of everybody will be on USCIS and its guidance in the next several weeks and months in order for the program to take off in May in the way that has been promised. Now, let's go to a couple of the other areas. They are both reasonably technical, but important to the success of the deferred action. One has to do with waivers. 601A waivers, which are already in place. These are waivers that have to do with allowing people eligible for visas to know in advance whether they would be subject to bars to reentering the country, the 3- and 10-year bars, when they pick up the visa in their home country for which they're eligible. That waiver has been available to people who are children and spouses of U.S. citizens. This current program now expands that eligibility to lawful permanent residents. We believe that about 1.5 million unauthorized immigrants are spouses of a U.S. citizen or LPR, and that includes about 1 million people who would not be eligible for DACA or for the new deferred action on the part of parents. So this is an important additional benefit and ability for unauthorized people who are unauthorized to achieve a status. In addition, this part of the announcement promises to clarify the extreme hardship standard by which provisional waivers are decided, and there's a suggestion that there may be consideration of introducing a presumption of extreme hardship for some part of the caseload. So this next step is going to take the next steps in this part of the announcement take longer to accomplish because they will require regulations. And so USCIS will be amending its 2013 regulation for waivers, and they will be issuing new guidance on the definition of hardship at some point in the future. When, we don't know. That's important in order for this program to solidify, but what that extreme hardship guideline will look like and whether there will be a presumption are the key issues that will be important to watch. Finally, advanced parole, the announcement included the information that there will be a clarification in advanced parole that leaving the country does not trigger a 3 or 10-year bar to reentry. This applies to people who have deferred action because deferred action beneficiaries, both under DACA and under the new deferred action for parents, does give people eligibility for advanced parole. So what we need to watch now is for what the legal guidance will be that DHS will issue on how advanced parole will be handled. And then there is a legal difficulty that will need to be resolved at some point in the future, which has to do with how advanced parole affects eligibility for lawful permanent resident status, because deferred action recipients are clearly not to be eligible for lawful permanent residence, and yet a legal reentry under advanced parole can confer that eligibility. So that contradiction will need to be resolved in the future. I'm going to now hand the baton to my colleague, Moose. Moose, are you there?
Yeah, we can go to Margie and come back to
Well, why don't we move then to our fourth speaker and see if we can recover Moose Chishti as Margie McHugh discusses some of the implications, some of the elements of the executive order that deal with naturalization and immigrant integration. Margie, you want to
Sure.
say a few words here?
Great. Thank you, Michael. I think I'll start with the naturalization provisions. So first of all, for those of you who follow these issues, you know that there's been a lot of work over the last several years trying to remove barriers to the naturalization process. And so among the announcements was the decision that there will now be allowed a credit card payment option for the naturalization fee. Up until now, individuals were only allowed to pay that fee with a check or a money order. And then, very importantly, the executive orders address the feasibility of partial fee waivers. The existing fee waiver is an all-or-nothing proposition, and it's not available to persons whose income is above 150% of the federal poverty level. So now there will be a study on the feasibility of granting partial fee waivers, and that study will be part of the next USCIS fee study, which will be happening in 2016. And then additionally, there will be a new media campaign to encourage naturalization. It'll run in 10 states that are home to 75% of the overall lawful permanent resident population. In terms of next steps, in addition to the inclusion of the question of partial fee waivers in the next USCIS study, the credit card acceptance will begin as soon as is practicable, but no later than the end of 2015. Then the other big topic here is the announcement of the creation of a White House task force on new Americans. The task force is charged with developing a coordinated federal strategy to better integrate new Americans into communities and support state and local efforts to do the same. It will also help determine additional steps that the federal government can take to ensure that its programs and policies are serving diverse communities that include new Americans. The task force will be co-chaired by the Director of the Domestic Policy Council and the Secretary of Homeland Security, and it will include secretaries and leads from a wide range of federal agencies, including education, commerce, labor, health and human services, and others. In terms of next steps for that, within 120 days of the issuance of the memorandum, which is February 20th of 2015, the task force is charged with developing and submitting to the President an integration plan that will include recommendations for agency actions to further the integration of new Americans. And then also the task force will provide within 1 year a status report to the President regarding the implementation of the overall memorandum. So some of these provisions are similar to what was in S-744, the Senate Immigration Reform Bill, and also to a House bill, the New American Success Act, that was introduced earlier this year by Representatives Cardenas and Ileana Ross-Lehtinen. And it's a really dramatic step forward in terms of the federal government's approach to immigrant integration. While it doesn't go as far as the two bills that are on the table in terms of creating a formal consultation process between federal agencies and their state and local counterparts, nevertheless, it's the first time where we will explicitly have what we've been calling here at MPI the brain circuitry that federal agencies need in order to better respond to the impacts of immigration policies on state and local communities. And I think the big remaining question to look out for is this is such a fast timeline that's envisioned here. The idea that within just 4 months of the date of issuance that we would already have a plan submitted to the President. It's fantastic that there's the desire to make it happen that fast. But I think one of the things to look out for is whether how to avoid having this recount a lot of the efforts that are underway at the state and local level, but rather really look at those that align with effective practice and better outcomes for immigrant and refugee families in a number of areas of immigrant integration. But fantastic that this ambitious effort is part of all the executive actions, and certainly we expect that it's going to unleash a great deal of pent-up energy that's there at the state and local levels and also across federal agencies, where for a long time now there's been a great awareness of the need for this sort of brain circuitry and coordination, but up until now, no processes to allow it to happen.
Great. Thank you, Margie. All right, so we're still trying to connect with our colleague Muzaffar Chishti in the New York office. Technology is defeating us for the moment. So I think we'll proceed to questions. And the first question that frankly I have, and I'd like to ask Doris to talk a little bit about this. As we look through these PowerPoints at all these essentially 10 proposals, 10 different sets of proposals, is this a grab bag, or are there a few principles that underline that undergird a number of the proposals that are nested in immigration law, particularly around the parents and deferred and the deferred action for parents that have historical roots?
Okay, a couple of answers to that, but there's no question that the administration, in its search for how to put this together, made a clear decision to hew very closely to the immigration law as it exists and has existed since 1965. I mean, our current immigration system is one that is based on the principle of family unity within the parent, child, spouse unit, and the immigration law gives favored treatment to immigration, sometimes without any annual levels of numbers, and other times not, to people who are spouses and children and parents. So what the administration has done here is entirely consistent with the family connection elements of immigration law. That's clearly delineated in the legal opinion that undergirds the discussion of legal authority for the president to put deferred action into place. So the deferred action applying to parents of U.S. children, U.S. citizen children, and lawful permanent residents is a reflection of the principles that drive our immigration law, and is also a reflection of a commitment to family togetherness and to the protection of U.S. citizens, largely under the age of 18, to not have their families disrupted by deportation.
Excellent. Thank you, Doris. Now, I think we've reestablished connections with Muzaffar Chishti. Muz, do you want to take it away and talk to us a little bit about the skilled immigration dimensions of the Executive Act?
Can you hear me now?
Yes, we can hear you.
Can you hear? Okay, great.
Yes.
Thank you again, Michael, and sorry, folks, for my break. I didn't want to add suspense to this proceeding. So, as everyone has noted, that the parts of the executive action that have gotten most attention are regarding the treatment of the unauthorized presence of the U.S. There's also a significant component here of reform of at least the employment-based part of our immigration system. And they've been responsive to demands from businesses over a period of time, by immigrants waiting in long lines to get green cards, and people who want to enter to take part in our visa stream. So I think it's safe to say that this part of the executive action is geared to allow high-skilled people to enter the U.S. and also to move within the labor market in the United States. And the eye is on job creation, the eye is on economic growth. So their obviously attention is a lot more on innovators and investors. There's a lot of attention here for high-skilled immigrants in the H-1B category and their spouses. There's a lot of new attention on what students can do after they finish their degrees in the U.S. in terms of their entry into the labor market. There's a lot of attention of how companies should have easy access to move personnel within their multinational sort of operations. And there's also a lot of suggestion here that there is recognition that we must relook both the management and the streamlining of our immigration system by various agencies of the government, so that we finally have somewhat of a more functioning immigration selection system, which has sort of remained frozen in the 1990 changes in the immigration law. So here are sort of the brief elements of this. As everyone has pointed out, these are a lot of the details of this will be spelled out in the regulations and the guidance. So we know the details of it are sketchy, but the outline is quite clear. First, with respect to increasing options for innovators and inventors. I mean, there's clearly a lot of recognition that people want to take part in the enterprise of this country, either by their talent or by their resources, and don't have enough opportunities to do that. So the executive action would do two things with respect to opportunities for the innovators and investors. First, in our permanent legal immigration system, there's a category called the EB2. This is a relatively high priority category, and one of the prongs of that category allows people to get a permanent immigrant visa if it is shown that their presence in the labor market would be in the national interest of the United States. Now, there's been a lot of vague sort of guidance on what national interest is, but this executive action makes it clear that if you're an innovator, an investor, a researcher, someone who is entering the U.S. to create jobs, we want you to assume that you are advancing the national interests of the United States. So people of that category will be able to access the possibility of permanent residence without a job offer and without testing the labor market. These are obviously two major obstacles for people to be able to join the labor market on a permanent basis. The second is, I think for the first time, it allows people who are not here in the country, are abroad, but have the potential of being innovators or have access to capital which they have demonstrated in terms of being potential investors, or can show the promise of being job creators, that they will be able to enter the U.S. not on any non-immigrant visa, because the president could not create a new category for non-immigrant visa, but they'll be allowed to be paroled into the United States if there is promise that they will add to the labor market and the job creation that we believe investors and innovators can do. So for the first time, we'll have a new program of entry for this group of people. Now, obviously, some of these will require guidance and they'll require regulations. We are not clear how quickly they will be done. I think there'll be significant attention paid to how we create more clarity in the national interest waiver in the EB2 category. So I think those things will have to wait for the regulations and the guidance to come about. And I think the criteria, from my point of view, in deciding how do you gauge someone is a real innovator when that person is abroad, sort of the classic is how do you measure someone's fire in the belly before you decide to parole them in the United States, are some of those things, I think, which will be important unanswered questions. There are significant other changes in the employment-based system, and we don't have that much time, but first of all, with respect to the H-1B workers who have had their, who were waiting to have their immigrant visa obtained in the United States, and their application for the immigrant visa has been approved, but they haven't gotten their green card. They're waiting in this adjustment of status pipelines. And this will allow these people to move from one employer to another, or to move within the company which has sponsored them without jeopardizing their adjustment of status application. And I think this sort of has been, in the jargon, being called, they must move within similar or same employment category for which they were sponsored by the employer. It will clarify as to what that similar and same categories are, which would increase the ease of people to move and not be frozen in the job for which they were sponsored while they're waiting for their green card to come through. On the practical training, this has been somewhat a controversial issue that, as I'm sure all of you know, that after someone finishes their schooling in the U.S., they're allowed to get 12 months of practical training. In 2007, the agency guidelines allowed people in certain STEM fields to get additional 17 months, so a total of 29 months of practical training in the United States. The executive action seems to suggest that that time period may be extended, and the categories of degrees that are allowed to get this additional 17 months may be expanded beyond the subjects that are now categorized in the STEM degrees. So, you could potentially allow people to get 17 additional months of practical training if their minor may have been one of the STEM degrees, not major, or the bachelor's degree had been in STEM fields and not the master's degree. The third action here is with respect to the intra-company transfers. We allow in our immigration system today for companies to move their intercompany personnel from subsidiary to the U.S. and one subsidiary to the other if that person has specialized knowledge. There has been a lot of controversy about what specialized knowledge means, both with respect to the elements of it and consistency within various centers in the U.S. which process these applications. And the executive action seeks to sort of standardize that criteria so that people will have absolute much more clarity about when they can move their personnel. And the last one on this, particularly important, is that right now, if you're the spouse of an H-1B worker, these are people who are called H-4s, you don't have the right to work in the United States. This executive action would allow spouses of H-1Bs to work in the United States lawfully if their H-1B spouse has an approved I-140, which is the immigrant visa application, already approved. This is a big change and probably expected to affect more than 400,000 people the last time we heard. And this was a proposed regulation in the May of this year. A final regulation on this is expected by the middle of January. So the next steps on this are, again, we'll wait for the agency guidance and regulations on each of these things. There's also going to be some change coming in the way we give labor certifications in the United States by the Department of Labor. There's been a lot of controversy that the labor market test is actually not consistent with the real world test. So this is sort of more the Department of Labor's view of the world in terms of how people look for applicants, that there'll be some changes to make it more consistent with the real world practice. And I think we'll again see how the final regs on the spouses of H1s come through. Last thing I want to conclude by saying that there's obviously a lot of effort made here to see that whether we could improve the transparency and the efficiency of our employment-based visa system in general. And the president has this on this. He actually issued a special announcement on the day after November 20th by asking the Department of State and DHS to coordinate with all agencies which have a stake in the employment-based immigration system to come up with recommendations for improving how we track issuers of visa numbers. How do you let people know that the visas are available? How do you detect fraud? How do we test the labor market, both with respect to that labor protections are lived up to and U.S. workers are not harmed? And these recommendations are supposed to be in by the middle of March. And I think there are important questions here. One is, which business has had a lot of interest in, is that if some visas in the employment-based category have not been used in the past, will they be able to be recaptured for use by skilled workers who are waiting in lines? And that answer to that will affect a large number of people. And then the second relevance to us is that right now, if any employment-based visas are not used, they automatically filter into the family-based categories. If that is changed, obviously that's going to affect the family-based system then and may increase the backlogs in those. So all those scenarios, I think we'll have to wait and see how they evolve. Thank you.
Thank you very much, Moose. And I think, and now I think we're going to move to the question and answer. And if our computer is any guide, there are lots and lots of questions out there about the implementation of this executive action. And we'll start with the lightning round of questions about DACA and, if you will, DAPA for the moment. And we have a number of factual questions that I'm not perfectly certain we'll be able to answer, but we can at least ask around this table. So, Mark, maybe you might want to take a first cut at the question of if someone has a DACA renewal that's pending now, will the USCIS approve it for 2 or 3 years?
We've been told that it will be that they'll approve it for 3 years, and that people who were recently renewed for 2 years will also get the 3-year renewal. So that process should be automatic, is what we've been told.
Okay, great. And the second question is, does the $465 form price of the fee, does it include a biometric fee?
Yes.
Does include. Third question is, does it apply? Are same-sex partners eligible for deferred action?
So I think this falls into the category of they haven't written the rules yet for the deferred action. You know, the deferred action for parents won't start for 6 months, and a number of questions like this are still being resolved within the agency, and those we'll find out the answer to that when they publish the actual guidance for the program.
And so, by the same token, step parents will be defined at a later date, right?
Yes.
Is there any issue? Is there any clarity yet on whether taxes will have to be repaid in order to be eligible for the new deferred action program?
The President has talked a lot about paying taxes as a requirement for the program. It's not clear whether that's going to be paying back taxes or paying taxes going forward. So I think that's also something that is to be determined. I've seen discussion that suggests both things, but you know, Doris mentioned before the challenges that will be associated with proving 5 years of continuous residence. There will be additional challenges if unauthorized parents are required to document exactly what taxes they paid and what their previous tax liabilities were, and so I suspect it'll be a going forward requirement.
Okay, and a couple of other eligibility questions. Would people with executed final orders entering before 2010 be eligible for DAPA?
My read is that they should be. If they have been convicted of illegal reentry as a felony offense, that would likely disqualify them, because then there'll be an enforcement priority. But people with you know, previous removal orders who then reenter, the reinstatement of a removal order would not disqualify you from the deferred action, as I understand it.
And what will happen to people who receive DAPA after 3 years?
I mean, this is one of the many questions about, one of the many limitations of addressing these issues through the executive action is that we don't know what will happen. It will be up to a future president to either create a renewal or to a future Congress to come up with a more permanent solution for unauthorized immigrants and for those who benefit from these deferred action programs.
Okay, so we have a slightly more, a broader, less factual question, but a provocative one nonetheless. Margie, given our large experience with the DACA program, what do you think would be considered a successful participation rate in the DAPA program going forward?
Oh boy, for DAPA or DACA?
You take your pick.
Okay. So, well,
hopefully reach both.
I think if you look at the DACA program, it's DACA. It's important to think about participation rate for whom. And so, for folks who are familiar with our DACA at 2 report, we were careful to include a table in it that showed that there's a few ways to calculate the participation rate. If you look at everyone who is potentially who was potentially eligible for the program at the time that we were calculating the rate, you could say that the rate was only 37%, but that was including everyone who was the right age, dated arrival, et cetera, but who just didn't meet, who didn't meet. It included those who didn't meet the education requirement, which was that if you were basically it was older individuals who didn't have a high school diploma or equivalent and weren't enrolled in a program. You could also say that the rate was 55% if you look at those who did actually meet that education requirement. So I think in terms of what one might say would be a desirable rate, you know, certainly looking at that range from 37% to 55% under DACA, I think a lot of folks are thinking about how does one increase the application rate overall for the folks who are lower educated, and that's also a big priority as we look ahead. If there is going to be legislation, if it is modeled on the DREAM Act, then it is a big concern that folks aren't, that you could say that the rate is as low as 37%. I think given that rate for DACA, it would probably be hard, those rates or that range of rates for DACA, at least I would say that it would be surprising if the rates under DACA exceeded those.
Okay, yeah, thanks, Margie. And of course, this DACA is going to be introduced in a quite different political climate than DACA was, and much closer to an election. You know, it's not implemented. If it won't be implemented for 6 months, it won't be implemented till May 2015. And if it takes a year to get to approvals, that'll take you to May 2016, and in very much the teeth of a presidential election. We have an interesting question here, Doris. How, kind of a broad general question, how do you think the provisions of this executive action is going to affect the immigration courts, and in what way? Do you think that which provisions will, and in which way? And
I think this is very much an important downstream question that will take some while to understand, but Mark laid it out pretty carefully in his comments, because one of the elements of the program is to do basically a docket review. In other words, everybody that is currently in deportation proceedings, scheduled for a hearing or scheduled for deportation, will be reviewed. The case will be eligible for deferred action if the person would meet the criteria for deferred action, and that can have an effect on the pending caseload before immigration judges. Now, it might not be a large effect, because it is also the case that the large majority of people that are currently removed from the country are removed non-judicially. In other words, they're removed either through expedited removal or reinstatement of earlier orders. It's the minority of cases that actually come about, whose removal comes about through the order of an immigration judge. So the docket review might result in fairly significant reductions in the size of the numbers in the queue, and still not heavily affect the caseload of immigration judges. But it certainly will affect the caseload of immigration judges to an extent, and that will be an important corollary effect. It should mean that people on the non-detained docket, all things being equal, are likely to have their cases adjudicated in a slightly more timely fashion. Many of those people are people who are applying for asylum. So one outcome here that one could imagine is that asylum applicants and those who are particularly important, those with meritorious asylum claims, will be able to get a decision and move on with their lives slightly more quickly.
Here's a question we've been struggling with. Since the DAPA program is going to be fee-based, right, will USCIS have the resources to prepare to adjudicate applications before they arrive? Mark,
well, we know that USCIS has already begun laying some of the groundwork and is doing some hiring and has been anticipating this program. So they will put in place some of the infrastructure to adjudicate cases. They will depend on those fees coming in order to sustain those operations and to manage the surge in resources that the surge in operations that they'll have to sustain to cover all these new applications.
Great.
And that sort of puts on hold the questions about what may happen during the appropriations process and whether whether congressional Republicans will seek to put restrictions on that spending and whether they'll be able to, because there's a lot of questions about their ability through the appropriations process to restrict USCIS operations, or whether they would have to go through the regular legislative process to do that, you know, not on a must-pass bill.
Okay, here's a question we have to get in before we end in a few minutes. When and will MPI be able to break down who will be eligible for DAPA and DACA with regard to country of origin?
Well, as you know, we have the state-by-state DACA and DAPA numbers already on our website, and you can get to that through our data hub, through the tool that, you know, the interactive tool that will allow you to look at that. We are right now in the process of trying to do some additional analysis to look at things like country of origin breakdown and country of origin breakdown in states and several other, you know, we'll be putting up or doing the analysis on several other breaks like that within the next few weeks, hopefully within the next couple of weeks.
Doris, do we know anything about how ICE is going to monitor field conformance with the new priorities, and will there be any transparency to that process?
Well, we do know from the analysis that we did and that Mark described earlier that there was high conformance with the earlier prosecutorial discretion memos that are known as the Morton memos. So there is, at least in the recent period and currently, a pattern, and it is, one can validate it in the data, of conformance with the guidance. Now, that does not necessarily account for possible differences from location to location, and in the current changes that are contemplated, it's not only the deportation guidelines, but the changes in secure communities that will be in play. Changes in secure communities are, in the secure communities program, are substantial and do allow for important areas of judgment to be exercised at the field office level. But I must say that there, you know, there is in the deportation analyses that we've done in the most recent report that was authored by Mark with the 10 years of data from the Department of Homeland Security during ICE's entire life, a very, very close alignment between the guidance and the actual results. I think that probably the real change that we'll see here is that the removal priorities have changed significantly, so that where there have been concerns about the way in which the guidelines were implemented in the past have really been more concerns about the guidelines themselves than that they have been implemented in conformance with what the priorities have been. The change that we're likely to see here is that the priorities themselves have been significantly tightened, and so that should ripple through based on the way in which it has rippled through in the past.
And one of the other things that Secretary Johnson talked about in that memo and in the rest of the announcement is collecting additional data and making it available to help MPI and others monitor how closely they're adhering to those new guidelines. So hopefully we'll see greater transparency and continued ability to check them, check their data.
Good question just came in. If you can't apply for DAPA until May, what happens if you get picked up between now and then?
So the memos, the memo on the deferred action for parents directs ICE and CBP to begin exercising discretion against people who will be able to apply. So they should be able to apply defensively beginning immediately, both for people entering the system now and for people who are already in removal proceedings but don't yet have final orders.
And I guess a final question. What wasn't here that people expected in the executive action?
Well, of course, the big piece that people...
It's a speculative question.
It's a big piece that around which so much of the advocacy was mobilizing was the parents of current DACA recipients. And that, of course, is not in the action, and it's not in the action for reasons that are carefully outlined in the legal opinion, but that is the difference between what it is that might have been, well, clearly was an expectation, but an expectation that is not going to be able to be satisfied or is not being satisfied in this executive action. Just points once more to the importance of a legislative solution and a congressional action on these issues, because at the end of the day, what the President has done in this executive action, both with the Deferred Action Program for parents as well as these many other measures that we've been describing, this really has been quite a sweeping whole-of-government policy initiative, is still nonetheless falls short of some people's expectations and certainly of an overall response to the issue of unauthorized immigration.
Okay, so we'll take this one last question, and then we'll close. Maybe, Mark, you could say a little bit more about the changes to the Secure Communities program and what the impact of those changes you think will be.
So under the existing Secure Communities program, anytime somebody is booked into a local jail or prison, when that arresting agency runs a background check on them, they send their fingerprints to FBI, FBI shares the fingerprints with DHS, and if there's any hit in the DHS database, the local ICE field office is notified, and they may place a detainer on the person to request the arresting agency to hold them until ICE can pick them up and put them in removal proceedings. Under the new program, as it's been described, the sort of technology will work the same way. The fingerprints will still be automatically checked and will be shared with DHS. The difference is that ICE will only follow up with people who have been convicted of a crime that is identified in the Johnson priorities memo. So convicted of a felony or an aggravated felony or a serious misdemeanor or multiple misdemeanors. And in those cases, ICE will follow up by requesting that they are notified prior to the person's release, but they will not place a detainer to request that the person be held. They'll just try to be notified and then be able to be in a position to take custody in the normal at the point of a normal release. What we don't know yet is exactly how those changes are going to be implemented. One scenario is that the ICE will use its centralized technology to only notify the field offices when it's a convicted criminal and a priority convicted criminal. And in that case, we can feel confident that the field offices will only take custody in those cases because those are the only ones they'll know about. I think the way I read the announcement is that the field offices are still going to be notified and they will be directed to only take custody of convicted criminals. So that will, if that's how the new program operates, it will leave in place, the opportunity for variation across different ICE jurisdictions of how closely they adhere to that new program. So that's something we'll be watching, and hopefully we'll have the data to monitor that.
Okay, thanks, Mark. And I want to thank the audience for listening and for their penetrating questions. I want to thank our speakers, and I want to thank our MPI team, including Sarah Pierce and Faye Hibsman, who helped us get our arms around this remarkably complex multi-agency set of policy shifts. And if you have any questions that are unanswered, it's probably because we got so many questions over the course of this past hour. But for reporters, if you on the call who have further questions, please call Michelle Middlestat, and her number is 202-266-1037. And as a reminder, the report, audio, and the slides from today's call will be available on our website later today at www.migrationpolicy.org. There won't be a report, but there are plenty of reports, and our slides will be available. So thank you again very much for listening, and have a nice day.